welcome everyone to the Moroccan Post. Moroccan Post. You can find Moroccan Post on Facebook as well as on YouTube. Yes, we have the Moroccan Post is sponsored by the Academy of Providence. So we allowed the get this. We're able to do this because of the Academy of Providence, and that's the online school as well as the in-person school. And so we're definitely helping. Happy to be sponsored by the Moroccan Post. I mean, the Academy of Providence. Now, if you want to donate, you can go to send to the Cash App, Tamara D. Ill, Cash App Tamara D. Ill. We'll also have the information that'll be rolling on the screen, as well as we have an upcoming course, the Hooked on Grammar 301. Yours truly, Abdullah Talib Mosi Bey, will be the instructor of that course that is upcoming on January 27th, Thursday, January 27th, from 7 p.m. to 9 p.m. Eastern Standard Time. It's a 12-week course. The course will be recorded. And so if you're not able to take the course on Thursday, you can still take the course, as the course will be viewed live via Zoom, and the recording we uploaded onto the student portal. All right, so I thank you for joining us on the Moroccan Post. Happy Ratification Day. Happy Ratification Day, everyone. Why is Abdullah saying Happy Ratification Day? We're going to get right into it. Well, this is part one of a three-part series. Part one of a three-part series. We have a lot of information. That's why we had to break it up into three parts. We don't want to leave anybody hanging. This is a very important presentation. It'll just to give us a proper concept of what we need to do as a people, understanding original jurisdiction, understanding who are the high contracting parties. All right, so we're going to get right into it. All right, so once again, happy Ratification Day. Checkmate. The crown owns the United States. The crown owns the United States. Ratification Day, January 14, 1784. The political impact of the definitive peace treaty between Great Britain and the United States, signed the 3rd of September, 1783, known as the Treaty of Paris of 1783. All right. Fun fact, 1983, the bicentennial stamp commemorating the ratification of the Treaty of Paris of 1783. Over 100,000 stamps were printed, something you may have not even known about. So this is a good fun fact for you. All right. Yes. So they have the Treaty of Paris. Now, the Treaty of Paris ended the Revolutionary War between the United States and Great Britain. And then Article 1 of the Treaty of Paris, Great Britain acknowledges the United States, viz, which means namely, and all 13 are named: New Jersey, Massachusetts, Plantation, you have the Rhode Island Plantation, South Carolina, North Carolina, Georgia, Maryland, Pennsylvania. Each of them are named named individually. United States acknowledges, namely, as free, sovereign, and independent states. As free, sovereign, and independent states. Now, it also states that Great Britain relinquishes. The word is relinquish. The word is not cede. The word is relinquish. So that's very important to pay attention to. that Great Britain did not cede, neither ceded, grant, or conveyed. Great Britain relinquished, which means relinquish means to leave. So it's not an advance, not a secession. So therefore, it's not a secession treaty. It's not a secession treaty because the word cede, it's not in the treaty. Shem, you want to add to that?
Yes, the Crown relinquished the authority over that political organization, meaning that they was allowed to vote. They was allowed to vote. The judiciary, the Congress, the legislature, and the executive. So you had three branches of government under the old colony. They didn't have power to vote or decision making. So when they established the states, the political organization states, they allowed them to go in as a franchise to do business as a company. So now they was allowed to go in now and elect their board of directors, elect their governor of the state, and elect their judiciary. They hear the disputes. Also, remember, this is all industry because they had to borrow money. So by being allowed to go back into the colony jurisdiction dominion, they was allowed the United States, the United States, right? The United States was allowed to take the people, to tax the people again, and tax their income and tax their estates, and take the money they paid back. So much of the portion they had to go back to the Lord Prosperators, and also the proprietors, the Lord Proprietors, and also to the freeholders and to the crown and the royal family. That money was to go back to pay the loan and also to pay for any use of the colony territory. Also, the Bar Association received a slice as the statutory bar of the pie. Because they remember now the investment power was in the Congress. And when you say invested, that's inherit. So how did Congress inherit that right? The author, the drafter of that instrument, which is the Esquires, was instructed by we the people, was the law proprietors. The law proprietors was the one that instructed them. When they draft the instrument, the crown and the law proprietors was the one that instructed them. They put the inherent power in Congress. Now, why would they put the inherent power in Congress? Because always under the old common law, the Esquires was always the one that did all the drafting for the king and the lords and the freeholders. Okay, go ahead, Abdullah.
All right. The United States is not the successor of the British Crown. It has been in the United States schools on all grade levels that the United States defeated the English British Crown in the Revolutionary War. As a result, became the sovereign authority over all the 13 English British colonies in 1783. Note, the United States is a sufficient fiduciary guardian of the British Crown. So, in the schools, it's taught that the United States defeated Great Britain and that the 13 colonies became the states. This is a very key concept to come to understand, that the 13 colonies became the 13 states. So let's analyze that. Let's go into before we do that, we're going right to the fiduciary guardian of the United States is the fiduciary guardian of the British Crown.
Yeah, you have your phone?
Good.
You have your phone with you? I want to read it. I want to.
No, I said
Okay,
no.
okay. You
I
don't
said
have
no.
your phone. Fiduciary. Fiduciary is the United States has been placed in a position of discharging the debts and collecting debts and discharging debts on behalf of the Crown. Meaning the new United States had an obligation, and it was stipulated that they have to pay back the Crown on a loan, and they have to pay back occupying the colony territory that was chartered to the Lords. Now, they had to collect the debt. They had to do the accounting. And how they did that was by, in the political jurisdiction of the United States, the companies, individual states companies. They was running industry. Now, they had to, by people running cattle, agriculture, fishing, and exchange, bartering, trading, and, trading, bartering, and exchange of the goods. And through the platform, the ships coming into the docks, in and out the ports, and going onto the platforms, unloading merchandise and cargo. Everything had to be accounted for and taxed. And the money that they are using in the colony is not their own money. They're using their crown money, England, Great Britain. That's not their money. So the United States was put in a position to pay back the crown. They have to collect tongues and taxes from the people on their income or on their trade or investment. So the United States is put now into a fiduciary relationship under legal ethics based on a treaty. They had a right to take the money, collect the money, and also they had a right to use the people as surety to pay back the debt, the loans. The people became the commodities, and in the political jurisdiction where the people did agriculture, where the people did fishing and trade, and the ships coming in and out of the ports, they was taxed. They had to pay fines, commissions on imports. Even on the very houses that they had to pay taxes on the erections and the occupying territory. So because the United States through Congress legislate the laws governing commerce and trade, that placed the United States in a fiduciary position because that was placed upon them through legal ethics to the treaty of 1783, the Versailles Treaty between Great Britain and the United States. Yes, I'd like for Tamara to read the IRS. And the reason why I use that, because that is the 1040 and the 1099 OID, the 1099, 1040. These are the things that's out that the United States use enforcing their fiduciary relationship with the Crown based on these tax filings. And the moment that you violate that, the IRS, a foreign accounting agency, goes to the Attorney General, Assistant Attorney General, and they take you to the federal court and they come against you and prosecute you. Okay, Tamara. Yes. So you understand the fiduciary relationship that's placed on the United States through legal ethics. Thank you. Okay, define. Fiduciary is defined. A fiduciary is any person in a position of confidence acting on behalf of another person. Fiduciary assume the power, rights, and duties and privileges of the person or entity on whose behalf he or she is acting. Example of fiduciaries, including administrators, what we talked about downstairs, me and Tamara Abdullah, conservators, designation, executors, executives, guardians, receivers, trustees of a trust. Trustees in bankruptcy. Now, we're dealing with this. I'm going to explain this from trustees in bankruptcy. United States, under the 17 United States of the United States, the states, not the colonies. This is the rebels and the certain ranking British officers that rose up against the crown and used the planners to fight their war. That's what was going on. they had to flee the colony territory, and therefore they was taken in by the Lenape Moors and entered into a treaty of 1778 called the Delaware Treaty. In that treaty, the Delaware Moors grant them amnesty and asylum. Now, asylum means protection from your enemy and feed you. So they was protected from their enemies, fed, and taken care of. Amnesty means it became friendship. They gave them a right hand of fellowship, friendship. Now, that United States didn't have any money. They was being taken care of. In order to get back in good standing with the crown, they needed the lords that was receiving the original charter, that was over the original charter, the ones that rose up in British ranks with the subjects. They had to go back to the lords that had the charters and negotiate with the lords so the lords can go back to the crown and the privacy council and allow them to come in peace and friendship through a treaty, which the treaty of 1783. It started from the 1782 treaty with Great Britain and United States, when United States borrowed large sums of money. They didn't have any money. They was broke. They couldn't run industry in the Lenape territory because under Articles of Confederacy, they didn't have the authority to go back into the colony territory. Now, what we have here is we getting a proper history lesson of what's going on here. The United States met with Great Britain in 1783 and entered into a peace treaty. Now, you don't have to enter a peace treaty if you want a war. You want to what? Surrender. There was never no surrender. They was not even in the place of winning the war. So they came through the lords and the other British ranking officers. They decided to allow them to come back and enter into a treaty, and they, under the authority of their lords and the crown, the Esquires wrote the instrument. Now, the United States now needed money. They need finance. The crown lent them finance, Great Britain. That money had to be paid back in futures. This is the word future coming in. That means now the people, the planners, all their prosperity, they growing, their wealth, trading, borrowing, investments is all not theirs. They're only given a privilege and grant to use the colony territory as a franchise to do business, commerce, which is the company. United States borrowed the money and used the people as sureties to pay back the loans. Therefore, that placed the United States in a fiduciary position on the legal ethics of the treaty. Now, I'm going to go on. Yes, I'm going to go on. Personal representatives, you know you're familiar with this. Go into your probate statute or any county or township, you're going to see the word conservatorship. Designees, executor, guardian, receiver, trustee, in bankruptcy, personal representatives. Now you will see personal representative on a Social Security form they got. When you one represent someone as an incapacitated person or special needy, they come in as a personal representative. Most of them are Esquire attorneys. A person in possession of property of a deceased estate or debtor in possession of assets and a bankruptcy proceeding by order of a court. Now, the United States is always in bankruptcy with the crown. They never got out of it. They always have, as long as they operate in a colony as independent states, companies, industries, they always have to pay the crown, the lords, and the freeholders tribute for everything they've done. The very money system that they operate under is not theirs. It's for the crown. It's of the crown and the lords. So they don't have anything. Now, a person is an individual, trust, estate, partner, associated company, or corporation. Now we get to somewhere. Deceased estates. This is the part that I want to get to right here. Oh, okay. Okay, deceased estates. A deceased estate is a taxable entity separated from deceased that comes into existence at the time of the deceased death. Now, what happened here is we're dealing with consciousness here. The Moors are not dead. The Moorish women are having babies, the Moorish men are making babies. Physically, we're not dead. What happened is we're in a dead state of conscience, not knowing who we are, not possessing the land, not inheriting the education and the philosophies so we can hold our lands, so we can hand down to our descent, kinsmanship heirs, our inherit. So what happened is we are considered deceased consciously of political what? Status, political identity. We don't have a nationhood. We're not in conscious of nation and statehood to run civics, political, economics, industry. We're not in a position to know this, so we consider dead at the deceased state, not physically, mentally, of what? Political running government. The entity that's created is under race, constructive language. When they call you a Negro, Mexican, Indian, black, colored, Afro-American. That is a state of decease, of conscience. What it does is unconsciously deprive you of your nationality and disnationalize you and makes you a deceased, consciously deceased to what, Shem? Deceased politically existing as a native Moor over the land. So you have to know what's going on here when they say deceased, when they're using that word. Now, the new created creature, black man, Negro, Mexican, that is a new entity created through racism. Professor Abdullah, you elaborate on that real briefly?
Yes, the racial construct is a political and social construct created in the 1600s, beginning with Johann Francois Bonner. Francois Bonner, who actually lived in Sindhu, modern day the British zone, India, for 9 years, and so he was the first one that created the political construct and racial construct of Mongoloid, Caucasoid, Afrosoid, and that was expanded by Carl Linnaeus in the 1700s. The black, white, red, yellow, and Johann Friedrich Blumenbach in the late 1790s added brown to the classification. This is not based in genetics, biology. It is a political, social, birthright stealing
That's right.
construct.
Yes.
There's no connection to inheritance, bloodline, genetics, or biology. It's all political. There's still the
Right.
inheritance and birthright exceeding, not about by using that race construct. The indigenous people throughout the world are not able to hand down their estates. I said throughout the world. I'm not, because this construct is used in many parts of the world. So not just here in this part of Morocco.
Yes,
Right.
I appreciate it. Yes. Now I get further back into deceased estates. Thank you, Professor Abdullah.
I have a question. In today's information, there's a new wave of information such as to analyze called a critical race theory. Now, you just went over yesterday's events that talk about how the construction of the racial constructs were set up by Blumenbach and Linnaeus. Now, how does that relate to today's information that's dealing with the critical race theory that's out in the society for them to analyze the critical race theory? And it appears to be an acceptance of the racial constructs. Could you go into that?
Let me do this. This will hit it home. Several years ago, I was working as a substitute teacher in the Kansas City school, and I was it was lunchtime, and I was in the teachers' lounge with about 10 teachers. We were around the table, and I was talking about the racial construct, and and the origin of it, and that nationalities, that people are identified by nationalities, not by shades and colors, you know. And one of the teachers blurted out and said, nationality is not the real world. So I said, well, yes, nationality is the real world. You have, as example, China, Chinese, Germany, German, France, French. It took me quite some time to understand why this teacher would say that nationality is not the real world. And it dawned on me back actually rather recently. I said, oh, I get it. All her life, she's been indoctrinated with the Francois Bernier, Carl Linnaeus, Johann Friedrich Blumenbach race paradigm. You know, when she went to school, you know, her mother had to check off black or Negro. And then when she had children, and so when she had children in the hospital, she checked off black. And then when she went to different jobs, and then as a teacher, she has to count for how many students she has, how many blacks, how many Hispanics, how many whites. So this is her paradigm. This is what she's seen. She doesn't see nationality on any forms. You only see the word nationality on immigration forms. Only immigration forms would you see the word nationality. Nationality of origin, nationality. You don't see nationality on any job applications, you know, that she see any forms that she has to do for the school, her first schools. She doesn't see that. So I get it now. I got it. It took me some time on why she said nationality is not the real world. Because to her, the real world is race. Because that's what she sees. That's all she's seen on paperwork. She's judging the real world based on the job applications, hospital forms, you know, enrolling her children in the schools. That's all she sees. I get it now. So I use that to answer Tamara's question, because that's being applied today. That is the mindset of our people. Another teacher. Let me use, because this is hit home right here. I remember being in the bathroom right to school, and I was in the bathroom with, it was just me and him, another teacher, and I was talking about him about the race paradigm, and he agreed with me. He agreed. He said, "Yeah, Mr. Bay, but you know, what can we do about it? You know, he's born and raised in the new political state, Colombia. So he's, you know, he's aware of what I was talking about, because they see the word nationality. The word nationality is on immigration forms." Another teacher in the teacher's lounge also agreed with me, and she says, "Well, this is what we have to do, Mr. Bay. Remember, they're not going to rock the boat. They come from poor countries. They come from the Dominican Republic. They come from Colombia. You know, they come from poor countries. They're not going to rock the boat." They understood what I was talking about very well. Now, those Moors classified as black, nickel, colored didn't understand what I was talking about, because they didn't have the experience. They don't have the experience of, you know, seeing the word nationality on forms. Another one, students. I recall being in the classroom, and Rihanna came up and said, "Oh yeah, Rihanna's black." I said, "Why are you saying Rihanna's black?" "Well, what do you mean, Mr. Bay? You know, yeah, you're black. All right. You saying that I'm black? Why? Because of what you look like. What do you mean? So I said, all right. Sammy Sosa, as dark as I am, or was as dark. Sammy Sosa, my complexion. Then we have a Mexican, my complexion. A Dominican, my complexion. So what would you call them? Dominican, Mexican. Yeah, Mr. Bay. Hold on. I'm trying to understand you. You said that I'm black because of what I look like. Based on what you said, it doesn't match. Well, why you call Sammy Sosa Cuban? Why did you call Sammy Sosa black? Why did you call me black and not Sammy Sosa black?
Yes.
Why do you refer to Sammy Sosa as Cuban, but you refer to me as black? We're the same complexion. Mister, I don't get it, mister. I don't get it. All right?
Are you a deep diver for knowledge? Do you like to explore historical content of language, grammar, and law? Well, Academy of Providence is a unique certificate-based virtual learning institution with an aim to draw out a person's innate talents and abilities by imparting the knowledge of languages, epistemology, scientific reasoning, jurisprudence, positive law, history, literature, rhetoric, and more. The channels through which those abilities would flourish and serve the communities as well as the nation. Our goal is to help you dive deep into critically analysis, thinking and reasoning of these areas towards becoming philosophers or humanity of learning or humanity of science, which creates society's great artists, painters, musicians, jurists, doctors, astronomers, biologists, engineers, cartographers, surveyors, photographers, chemists, herbalists, entrepreneurs, computer scientists, teachers, politicians, and statesmen. So, if you are determined and willing to go beyond, Academy of Providence is the perfect place for you. For more information, visit our website, www.academyofprovidence.org.
All right, so finishing up this point. So why use nationality, Mr. Bay? It's not on the forms. Why nationality? Race. What are you talking about? Nationality is not the real world. That's why. That's why she said nationality is not the real world. All right, so this is where Morocco comes in. Morocco, recovering our lost sovereignty. We have to claim our people. We have that is a massive violation of international law. That's denationalization on a massive scale for over a 400 year period. But a nation has to address that. As individuals, right? Meaning, as individual Moors, you will not be successful. Morocco has to do it, not the Moors. Morocco, all right. Do they say the Chinese or China? France, Germany, Nigeria, England, the Netherlands. These are so that the sovereignty is already vested in Morocco. It doesn't have to be done. It doesn't have to be done again. We're not a new state. It's an old state. So it doesn't have to be vesting sovereignty into creating a state. It's already, the sovereignty's already been created. There's already obligations. There's pre-existing treaties. In 1952, France, in the International Court of Justice, France and the United States, France used 3 types of treaties to adjudicate the case. And won the case based on using those Moorish treaties, 3 types of Moorish treaties. So you have the first type of treaties, the bilateral treaties between Morocco and 10 European powers between 1631 to 1892. The second type of treaties, or the treaties between, is the Act of Algiers, 1906, and the Act to Protect Morocco, 1880. The third type of treaty is the Fez Treaty, 1912. Let me finish. I'm going to finish this up here because it's answering Tamara's question. In 1968, Ceylon, Ceylon, the representatives of Ceylon argued against what the United Nations had had classified Ceylon as a new state. The representative went in front of the United Nations General Assembly of the International Law Commission, October 1968, and argued against that. He pointed to the 19th century, 1800s, that the Ceylon had extensive diplomatic relations with nations. So Morocco is not a new state. That's not a new sovereignty. It's a recovery of sovereignty, reversion to sovereignty, not a new state. All right, so I just wanted to bring that home.
Yes, appreciate it. Yes, I'm going to read the last dealing with fiduciaries, the termination of entities. A terminating entity, such as a corporation, partnership, trust. Now, you are considered as a corporation or trust. Your mother gave you the name. They made a corporation, and they made a trust. Only has legal capacity to establish a fiduciary relationship while it is in existence. Now, let me break this down to you. When you come to knowledge of your consanguinity, and you form your government structure based on the sovereignty already existing under Morocco, you claim to be a state or tribe of descent kinsmanship heirs that already existed and had possession rights before the occupying sovereigns got here. You have a right now to change the fiduciary relationship into your government or your trust, because your trust can take it over, which is the living trust of the national, with a cultural identity and a consanguinity and a political status connected to state. Once that happens, the government becomes the protector. Establishing a fiduciary relationship prior to the termination of the entity allows the fiduciary to represent the entity on all tax matters after it is terminated. Let me explain what it means. When you terminate the United States status as trustee, you have to go to the Social Security Administration to do that with a trust indenture. Once the United States, because the president appoints 7 to 6 trustees over the Social Security Fund, which is the old Survivor Pension Benefit Fund. That's the insurance fund. They run the whole world. All the nations invest in that. Their money system through that. Their industry, they agriculture, monetize. They're monetizing the commodities, the sureties. And the bank that holds the account is the World Bank for nations, governments. In the United States, they formed the Federal Reserve Bank, 12 districts. All the states have become banks and signed up under the President New Deal. So they gave up their sovereignty when they did that. They don't have no sovereignty anyway, because they lost that when General Lee ceded. So they lost the sovereignty anyway when he surrendered. He didn't enter a peace treaty. He surrendered to the District of Columbia. That's the new government. So I'm going to get back to this. When you take responsibility of your affairs and rise to the conscience of consanguinity and cultural identity, you come out of the status of being dead. And you come now back under nationality, protected under the laws of your culture. And anything that nation established through treaty, through Constitution, gives you a right. You got a right now to inherit the territorial jurisdiction. That means personal rights, private rights that already existed that are yours before the occupying sovereigns got here under conquest. That's very important. That's only can be raised as a government because the government, the Moorish government, Moroccan government becomes your protector. What do you mean, Shem? They represent you in the world court. They ratify the conventions and international agreements. When there's a dispute, the consul or ambassador speaks and defends the integrity of the Moorish government. No individual group can do that. Okay, Abdullah, you can go to the next one.
Yes. Thank you, Shem. Thank you. Great job with that.
Thank you.
Thought-provoking question. What is the ruling authority for the United States? A, United States Constitution. B, the definitive peace treaty between Great Britain and the United States of 1783, also known as the Treaty of Paris of 1783. So what is the ruling, Shem, what is the ruling authority for the United States?
B.
All right, you want to elaborate?
Well, B is the ruling authority, the Versailles Treaty of Peace. That France entered to a peace term and allowed them to exist in a colony territory as a franchise. Now, United States make a claim that they was independent in 1776. Now, if the United States is independent in 1776, there was no United States. It was the colonies, the 13 colonies. So in 1776, there was no United States under Articles of Confederacy. There was no United States of North America in the colony territory. There were the 13 colonies. So the 13 colonies are owned and controlled by the crown and the lords and the freeholders. So to make a claim that the United States that exists under the Jubilee is the same United States that was independent under the Declaration of Independence of 1776, there's no way you can prove that. No document can prove that.
Right. Let me
Abdullah.
add to this. All right. In the Treaty of Paris between the United States and Great Britain, the boundaries of the 13 British colonies on Moorish soil is outlined in there, also as well as what allows the 13 franchise states, not the 13 colonies, the 13 franchise states.
Yes, right.
To this day, January 14, 2022, is the Treaty of Paris and not the United States Constitution. You cannot show me in the United States Constitution any boundary markers for the 13 colonies. You cannot show me the language. Great Britain allowed the boundary markers, the agreement is in the Treaty of Paris, not in the United States Constitution. So to say that the United States Constitution is the ruling authority for them in the 13 colonies, the ruling authority in the Northwest Territory. No, it's the Treaty of Paris. They have to go back to the Treaty of Paris. If there is, in fact, there was a boundary dispute between Great Britain and the United States. Great Britain, that the boundary disputes, which also led to the Jay Treaty between Great Britain and the United States in 1795. So they went to where? The Treaty of Paris. To even iron out any boundary disputes.
That's right.
To know where the boundary markers are, who has the boundary markers. It's in the Treaty of Paris. It's not in the United States Constitution. It's not the ruling authority. So, go ahead, Sean. Just wanted to
Question,
provide that
Abdullah. So, Abdullah, it's safe to say that the treaty survey, the Crown was an authority to make the survey that distribute and delegate authority to United States where it should have its political jurisdiction.
All right, let's go back. Now, the survey for the Northwest Territory, the survey for Canada was done by France. It was done by France.
Yes.
From 1656 up until 1763, the Treaty of Paris between France and Great Britain that ended the 7-year Pontiac War. So it was France that surveyed.
Yes.
Not Great Britain. France.
Yes.
France ceded. The word cede is in the Treaty of Paris of 1763. The cede, not it has relinquish and cede, but the word cede is not in the Treaty of Paris between Great Britain and United States of 1783. Just look at these treaties. So why is the word cede? France cedes to Great Britain. Why is that in the 1763 Treaty of Paris? But why doesn't read Great Britain cedes to United States? It reads Great Britain relinquish. The words are not the same because both relinquish and cede are both in the 1763 Treaty of Paris between France and Great Britain.
Yes.
Both words are in there. So I gotta just throw facts. So the boundary markers is in the Treaty of Paris of 1763. That was first, all right, because it was already surveyed by France. France just ceded. They ceded the territory, large portion of Moorish territory, which is now, that's Canada. That's Canada. That's the Northwest Territory. And as a result, what allowed to this very day, the Treaty of Paris of 1783, not the United States Constitution. The United States Constitution does not give the United States any authority to be in the Northwest Territory. The United States Constitution doesn't give the United States any authority to be in the 13 colonies on Moorish soil. It is the Treaty of Paris.
Yes.
That's so. We want to make it very clear that the Treaty of Paris is the ruling authority for the United States.
Yes.
This is a 3-part series. This is a 3-part series. So tune in next month and also May and March. All right, because we got a lot more. All right, this is a 3-part series. So there's only so much we're going to present today. All right, we have a lot more to present.
Question.
All right, question.
Yes, we have an online thought-provoking question. Well, statement for clarification and to rule out any misconceptions. The treaty you talk about all the time is worthless. It was with the government of the Moroccan Empire, which ceased to exist in 1956. Therefore, the treaty ended in 1956. So you guys need to get a brain. Can you clear up that conception?
All right, don't hold it, Shem.
You guys that, go ahead.
Now, that means I have to go into what we're going to talk about in week 3. Class part 3, because we have treaties. We have United States Supreme Court cases.
That's right.
Society versus New Haven, Ware versus Hilton. So we have these Supreme Court cases that speaks otherwise. All right. That's what was stated is not a fact. The Supreme Court cases are the facts. The jurists the Supreme Court justices are not making that. You're talking about violating the Treaty of Paris, that the Supreme Court is going to make a ruling where the world is watching. The world is watching. Because if the Supreme Court errs on that, then the rest of the world with whom the United States has treaties are going to do what? Oh, shucks. They're not honoring treaties. They're not honoring the law of nations.
That's right. That's right.
Oh, shucks.
It's an act of war.
This is major.
That's right.
This is why the Supreme Court justices must be educated. They can't just arbitrarily make these. I appreciate the comment. Thank you. I appreciate the comment. We'll go into in March the cases. So Society versus New Haven, Ware versus Hilton. You have a host of other Supreme Court cases where it dealt with the confiscation, because in the Treaty of Paris of 1783, the loyalists or Tories, those who remain loyal with Great Britain and had to maintain allegiance, their right to recover land that had been confiscated. All of the franchise states in 1781 had enacted the Confiscation Act. Alexander Hamilton dealt with 60 cases of wealthy Tories dealing with the Confiscation Act, which is a violation of the Treaty of Paris. Also in the Treaty of Paris, that the Tories were able to allow to collect on debt before the war. In the 1823 case, Society versus New Haven, the Revolutionary War does not extinguish any pre-Revolutionary War debt or obligation. That's the Supreme Court, not Abdullah Bay. That's the United States Supreme Court, 1823, Society versus New Haven. That's the Society of the Propagated Faith and versus New Haven.
Yes.
Yeah, we got to present facts. I thank you. Please bring the comments. Please bring the questions. Please,
Yes.
please. I love it.
I'm not going to go into the. Okay.
Yeah, keep on going.
I'm
Yes.
going to go, Abdullah.
All right. Who are we, the people of the United States Constitution, in the preamble? We have we have a government by the people, a government of the people, a government for the people. Want to break that down, Shem?
Yes, a government by the people. The people is the crown, the lords, and the freeholders. The ones who received the charters, also the ones that the charter had given grants of land, who became patents. They become the freeholders. A government by the people is the crown and her privacy council, and a government of the people, mean of the lords, esquires, and a government for the people. That's the crown and her successors and heirs. That's it. It ain't the common people that was allowed to vote. No, the Constitution wasn't by them. They're not the people, because the same people that they boast in, John Adams, Thomas Jefferson, George, they're all esquires. So they're holding a ranking title under the crown, the Great Britain, the British crown. So you calling the subjects of the crown your founding fathers. See, you don't catch what's going on here. You better catch on what you're saying. You're not even recognizing what's going on here. You're calling the esquires the subjects of the crown that works for the lords and freeholders, your founding fathers. And you want to argue about don't hire an esquire, don't contract with an esquire. Well, that's the only reason why you got rights to vote, because of the esquire. That's who drafted the instrument, the esquire. He is the Sixth Amendment counsel under common law. There's no other officer or agent under the British crown and the colony territory that represented the crown the lords, the freeholders, all the planners was the Esquires. Go back and read, go back and look at the documents. There is no common people, subjects that represented the crown, that even represented themselves on a petition to the lords or the freeholders. So when you teach United States history or Moorish Americans or Moors that's unconscious, listen to me. You cannot say that the United States Constitution is the law to protect you, because the drafters of the instrument are British agents, esquires, and subjects. So you can't be partial with them and equal with them. It's impossible. You have a different status. Even say in the Constitution, no title of nobility. That's indigenous. That's indigenous woman. That's the one indigenous. Native Moors of the land. So we have to be careful. If you're a Moor, you got consanguinity. If you're unconscious, you don't know this concept. You have to go back and read and look at there's a vested and uninvested. Vested means it's inherent. Invested means you delegated authority. The people is delegated authority to vote. They were given permission in the new charter to vote. In the old colony charters, they couldn't vote. They couldn't even make any decisions. They had absolutely no control over their dynasty, over their direction in the British Empire. But as being a subject, paying taxes, fees on their goods, income. We have to realize what started the Revolutionary War is in the British ranks. There became a scam to overthrow the lords in the colony territory in the crown by certain British ranking officers, yes, and political power. They used the people as the pawns to fight the war, to try to overthrow and take control of the British colony because of the revenue. See, nobody talks about this. I can read this. I can go back and find this.
Keep on.
So what we have to understand, that you cannot take a people, descent, kinsmanship of immigrants that came off a boat that's not native to the land, and take a document that's drafted up by a foreign subject to a foreign crown and say that you get your benefits and your rights from that, your protection. You just nationalize yourself. You think you would add to that?
Well, you broke it down, Shem. We're going to continue. We'll continue. Yes. Good job. Who are the drafters of the United States Constitution? Have Esquires are given delegated authority by the crown to draft documents, and you actually went over that. Just reiterate that point, Shem.
And under the British, French, under Spanish, French, Portuguese, Irish, even the Catholic, Rome, the Roman Empire, and under the Greece, going all the way back to the ancient empires, they wasn't called Esquires then. It was called Juris Consultus. The modern name Esquire came later on, that represented the king and doing documents and draft and conducting certain commercial affairs with other nations. And the Esquires are the gentlemen ranking below a knight. So the Esquire was educated and put in position to go out under the 16th century opinionated ideology, methodology of the colleges of Europe. Their job was to go out, and when they write the treaties, and when they enter into agreements with the native people, their job was to identify the native people in the document as not being a native, but being of what? Being someone under title of racism, therefore they become deceased, because they wrote them in as an Indian or whatever they call them, black. That is a deceased. That means what deceased mean? You no longer exist with the consciousness of your blood relatives. You don't have no rights to the land anymore because someone called you something that your mother, father didn't consider themselves to be. And they renamed the land through a survey map, and you allow it to be done. Now, what is your proof to this? I'm going to prove it. When the Moors signed treaties. The Moors wrote the treaties themselves. The Esquire negotiated with the Moors, jurist consultants, but the jurist consultant of the Moor knew that was critical that you identify the native in the treaty, the instrument, to preserve that right to inherit. Now, the moment you don't put that there, there's no one that can inherit anything. That's it. That's a political death. And it's a strip away from cultural identity. Now you're dead to the law of the land that protect your people. You're not protected anymore. You want to add to that?
Oh, no. Good job, Shem. Good job. All right. Explain. We have here to explain the difference between the colonies and the states. All right. Explain the difference between the colonies and states. I'll start with that. All right. We want to look at the contract. So let's look at the royal land grants, the royal charters, the royal letter patents. Let's start with what people talk about colonies because of they're not looking at following the contract. They're looking at a tract of land. It doesn't start with a tract of land. Like say, well, the tract of land doesn't form the colony. The tract of land doesn't form the colony. You can't point to any tract of land and say, well, that's the colony, as that's the starting point. We gotta let's think like a jurist. Think like a jurist. What creates the colony? The royal charter, not the tract of land. The royal charter creates the colony. The royal charter, so you have companies, you have lord proprietors, William Penn, Duke of York, who are lord proprietors that granted Charles II in 1691, granted on 1664, he granted his brother, Duke of York, a charter to form a colony. And then in the land grant, there is the boundaries. So the crown is doing the survey, commissioned the surveys to do the survey. But it starts with the document. A jurist will look, and when we get into these cases, when we get into cases in the third in March, you will see that they're going back to what the instrument, the Supreme Court, and International Water Courts. They're looking at the charters. They're looking at the instrument. And Martin versus Waddle Lisi, Martin versus Waddle Lisi. And we'll get into details in these cases and March. They're looking at the charter, the land grant. They, and even in Spanish land grant cases, they're looking at the land grants. They're looking at the boundary markers. So when as we look into these cases, you see how jurists think. The tract of land is not the start of the colony. So I said I had to lay this out. I had to be clear on this point. So they say the colonies became the states. There is no instrument that anyone in the world can show me that. They can't. All right, so you have these royal land grants, these royal charters. That's the contract. So the charters were not amended. The colonies became the states. There's no amending. There's no like they have to be amended. That charter has to be amended and has to be agreed. The crown has to agree to that.
That's right.
The crown has to agree to amend an existing charter. All right, in order for the statement to exist, to be true, the colonies became the state. The only way that can be true is you present to me the pre-existing charter that was amended under the authority of the crown, that the crown sat down with representatives of the United States. In 1783, we got the treaty, but I'm not talking about the treaty now, where each charter, each royal charter, each royal letter patent, each royal land grant, where under King George III, who was king at the time, King George III, in the Privy Council, because it can't just be King George III, King George III in the Privy Council sat down with representatives of the United States, and they are amending the existing charters. And you got to show me the existing charter with an attached amendment. Think like a jurist.
That's right. That's right. That's right.
All right.
That's
You want to
right.
add to that, Shem?
Yes. Yes. It's clear and established that.
Keep going with the other one.
Okay.
All right.
Well,
Crown.
You broke that down. The crown and privy in that
All right.
council, the Lord
Proprietors.
Lord proprietors
Yes.
are the ones that have the colony charter. They are considered the lords.
William Penn.
That's right.
William Penn is a Lord Proprietor.
Yes,
Lord
yes,
Proprietor.
William Penn, yes.
Duke of York.
Duke of York, yes.
Lord Baltimore.
Oh boy, that's right.
All right. Lord
right.
Proprietor.
Yes,
All right. Lord Calvet.
that's right.
Lord Proprietor.
That's right.
All right. They Lord Proprietors were granted charters, royal charters, to set up proprietary colonies.
Right. And majority of them was the children or either a duke, a baron, or earl, a count, a marquis, or one of them. They will receive
Some were barons,
the lords. Yes, they will receive that. The esquires are the officers that drafted, that work for them, the drafting documents and litigation for the Lord Proprietors, the Crown and the Privy Council. The royal private charter was issued by the Crown at the permission of the Privy Council royal family. The royal land grant was given by the charter holders. Sometimes the royal land grant was given by the crown. The letter of patents came from the lords. I mean, they authorized someone to use the land for industry. The freeholders are the children of the letters of patent. They are the freeholders, meaning they hold the letter of grant, or that they hold the patent. I mean that for their mother, father, whoever it may be of that royal family.
Yes.
They're the freeholders. That means they still hold a stake, an interest in that the industry, in the tract of land that's considered a colony.
Yeah, they would be under the trust board.
That's right.
You know, when we get into the Dungan pattern,
Yes.
and in March, the Dungan pattern, you have the Board of Trustees, all right, and this is in New York. The Board of Trustees was under the Legislation Act of the franchise New York State.
Right.
Then you have the board, the council, the board, the charter, the Board of Trustees that was actually under the charter, that exists under the charter. So there's two boards now. One existing under the charter and one existing under New York State Legislative Act.
That's right. Absolutely. That's right.
So you're going to learn a lot
That's right.
through these cases.
That's right.
Think like a jurist.
Yes. As a matter of fact, even in the political status as a British subject, national, Indian, which is it's a political status as a British national, but absolutely have no cultural identities attached to more. It's just a political status, Indian. But even in the status of an Indian, you have to realize that even the United States applied positive law, jurisprudence. They look back even in that status as a British national. They still had the possession right and the inherent right to determine among themselves who they are. See, we have to take upon ourselves and rise to the conscious state of maturity and know that we have the inherent right to tell everybody, every nation in the world who we are, and not for them to make up a conclusion and draw a conclusion who we are, who our father and mothers are. When that happens, you stripped of everything in this world that protects you. In nature, you stripped. As a matter of fact, you don't even have control of your body. So you're not a Lord for the man. The divinity is the Lord. The Bella is your body. So if we don't even have the Bella, the Lord don't have control of the Bella. I mean, you don't have control of your body because someone is explaining to you who you are, your existence. So we have to get back to this, look back and get back to the cultural structure, the foundation line, the property line. We can't let nobody move that. We have to invoke and say our ancestors, even the seers say don't remove a line. That's a foundation line. Nationality is a foundation line. We can't move it.
All right.
Ready?
Yes. We have here, how are European newly created states, towns, boroughs formed on Moorish land in the U.S. jurisdiction? All right. Now let's go back to Happy Ratification Day. Let's go back to the Treaty of Paris,
Yes.
the ruling instrument for the United States. And the Treaty of Paris, Great Britain relinquished, allowing the United States the Northwest Territory. That Northwest Territory was under occupational control by France from 1656 to 1763. So from 1763 to 1783, when you under the Treaty of Paris of 1783, Great Britain allowed the United States to operate within that which was once, of course, it's a Moorish territory, then became under the British and French control, and then under, British control. For that, and then as a result, the United States Congress was able to enact the Northwest Territory and Northwest Ordinance in 1785. What allowed them to do that? Even today, that's Michigan, Ohio, Illinois, Wisconsin, Idaho, and Indiana. To this very day, it's not the United States Constitution. It is the Treaty of Paris. If there is a boundary dispute, which it was in 1790s, which led to the, as I said, to the J Treaty, which is the Treaty of Amity, Commerce, and Navigation between Great Britain and the United States. It's called the J Treaty because John, named after John Jay, who was
right.
Minister of Foreign Affairs during the 1780s, 1770s, and 1780s. That he became the Chief Justice. He was the first Chief Justice, John Jay. All right, so that's why it's so called the J Treaty. All right, because John Jay was instrumental in negotiating that. John Jay had to quell the people, they was all rowdy up. And so this is that treaty today allows the United States to operate, not the United States Constitution. The United States Constitution does not give them any authority to operate. If there is as I said, there was a boundary dispute in 1794 between Great Britain and the United States, they did not go to the United States Constitution.
Yes, right.
They didn't go to the United States Constitution to settle the boundary dispute.
That's right.
They went to the Treaty of Paris.
That's right.
I am demonstrating, we're not just saying the Treaty of Paris is the ruling instrument. So Supreme Court cases will support us.
Yes, it will.
Supreme Court's not saying the United States is the ruling state. Article 6 of the United States Constitution is not saying that. That treaties are supreme law of the land. Why? We're going to get into that. We're going to get into that. All right. So we have here. So now we have the Northwest Ordinance of 1795. And it was decided in July 1787 during the, not at the Constitutional Convention, but during the time period of the Constitutional Convention, which was from March 1787 to September 1787. In July of 1787, representatives of the United States decided to take the Northwest Territory, which was relinquished to them by Great Britain, and divide them into states. That was decided in July 1787. So this is key. So now, so you have these. So what governs the Northwest Territory is the Northwest Ordinance that was enacted by the United States Congress in 1785. And the Northwest Ordinance is the Constitution. That was the initial Constitution, no structure for Michigan, Ohio, Indiana, Wisconsin. All right, that was the initial Constitution because they were governed under the Northwest Ordinance.
That's right.
But once again, keep in mind, the boundaries of the Northwest Territory is in the Treaty of Paris.
Yes.
So, like I said, once again, if there's any disputes of boundaries,
right.
they're not going to the United States Constitution.
That's right. Yes. Oh, this is wonderful.
All right. So we have number 1, population. Note Article 6 of the Montevideo Convention. All right. So when a new state wanted to enter the Union, they had to have a population.
Yes.
So we refer to Article 6 of the Montevideo Convention of the Rights and Duties of States of 1933. 2, Constitution and Charters of the newly created states, counties, cities, towns, townships, boroughs. When a town, municipality, township, boroughs, they had to comply with they need a population, a prescribed territory.
Yep.
All right. To even bring in a petition for a state. Survey.
That's right.
3, architectural drawing and engineering development plan. 4. All right. So, all right. Government trust. Government trust is the Constitution. 1, settlers, drafters, consultants, Jewish consultants created the boundaries and delegation of authority for each branch of government. You want to go and explain that, Shem?
When the Constitution of the United States was being drafted, it was drafted by the Esquires. The Esquires is the drafters of the instruments. We, the people, the settlers, are the lords and the freeholders. They are the lords and freeholders. They are the ones that have to be protected. You got to go back and look at the old colony charters. When the old colony charters was made, the lords act as the governors. Sometimes the lords act as the parliament branch, and they handed down commissions to people they ordained. They are appointed. They also decided over the appellate matter, the appellate matters dealing with appealing small matters, disputes. So the lords had all that. They carried on all of them capacities, occupations. When the Esquires drafted the Constitution, you notice that they put the vested power in Congress. Now, we have to look at, right? Let's not run a 4. Let's stop right here at the drafting of the instrument. Who is Congress? Congress is the ones that are appointed by the lords and the crown to operate as the legislative branch, because in order to control the people, you got to give the vested power, the inherent power, to the Congress, the lawmakers, and they started off as esquires, and they're going to always be in control of the esquires. It's going to be in control of the lords. It's going to be in control of the crown, the privacy council, the pope, and the knights. They're always going to be in control of them. This is why I say vested power. That's inherent. That means the Congress inherit the power that the lords had under the colony charters.
All right. Number 2, Parliament, delegated authority in the Constitution as trustee. You did address that.
Yes.
All right. 3, Judiciary, bankers who discharge and settle disputes, criminal and civil. All right. Go into
Yes.
that.
Now let's go back to under the old colony charters. The lords and the freehold, the lords and the patnams, letters of patent, was the freeholders. They had what you call commissions. They were the ones that sat there in judgment on behalf of the lords, or the lords would sit in judgment to handle any dispute dealing with. In equity, you're dealing with criminal and civil. They're both the same. One is a damaged party, be physically damaged, mentally, or raped. All these things that still fall under equity, because you still merchandise. You still consider goods, merchandise, and collateral. So it's civil, but they call it criminal. They was able to adjust the matter the way they want. They was the trustees. That the Congress have the inherent power to manage the business of the lords and freeholders and the crown and the privacy council. They manage. Congress manage. Congress was granted an invested inherent right. What are they inherited? The same authority that the lords had under the old colonies. The lords wrote the legislator or hire commissions to write in the legislative body to write as they see fit. So the vested power went to Congress. Congress inherit what the settlers wanted them to do as trustees, to manage their money, the crown affairs and the lords affairs. So it's very important you understand what's going on here. Congress is in the Constitution, in order to say the vested power. And like Professor Abdullah broke it down, that's dealing with inherit. How do you inherit something? It got to be handed down to you, like handed down as something that if you my descent, my son or daughter. So United States Congress have the inherent power to make the laws and act as the trustees on behalf of the crown and the lords. So they are the trustees. That's the parliament. That's who make the laws.
Number 4, the citizens, beneficiaries.
Now the citizens are the beneficiaries to this part. They special needy. They got a mental handicap condition of consciousness, meaning that anyone that's been granted something by the lords or the crown, they have a subject status. Number 1, they're not in their own land, so that's an immigration status. They're planners. They work in the industry under servitude. So they talk about us and try to say, "Oh, we servitude." Oh, no, they are too. They are too. Their whole life, they don't have a national origin. They can't claim a native origin here in Morocco. This is not their native land. So they are the beneficiaries, but at the same time, they are sureties of the trust. Remember the trust. There's a trust. Now let me go deeper than this. The lords and their descendants and kinsmanship successors, the letters of patent, letters of grant, a patent, and freeholders, they are the first beneficiaries to the trust of the charter colony. Please hear me out. The planners are the beneficiary of the new social trust under the Jubilee. It's different status here. One has a freehold status as a beneficiary. That's inherent. That can be handed down. The other one is granted the right as a beneficiary under an instrument drafted by the Esquires. That's the difference. When something is inherent and something is granted, that means you being donated, a donor. You don't have anything. You don't own anything. When you got a beneficiary right through a descent, kinsmanship, or heirship, that's a different beneficiary status under a certain trust. Go ahead, Abdullah.
All right.
You know,
Five.
Yes, Tamara.
Before you go further, I want the listening audience and the viewing audience to be able to truly understand that you just broke down the elements of a trust. And through the variation understanding of the trust, there's a element to it. You have the settler, and there's another. The settler could also be called the creator, or the grantor, or the donor. And then you have the second part. You have is the trustee to the trust, and the trustee to the trust you just identified. Here is the delegated authority under the parliament. It's the trustee. The parliament is the trustee to the trust of the Constitution of the United States. Then you have the third element, which is the beneficiaries of the trust that was set up. Now let's think of what goes into that trust. Now, in order to make this trust work, you have to have some type of property that goes into a trust, which is called a corpus, a res, a state. Could you go into that a little bit? Because
Okay.
that's how the trust operate. It operates through what you place in the trust.
Okay, now I'm glad you asked that question, and we're going to clarify this. You notice that any trust, any old trust done by Moors, they want you will never see it. So I have to use the Rothschilds, because the Rothschilds use the pattern of descent, kinsmanship, and heirship in the trust. Now, in the trust is the exchanger or the settler, the trustees, and the beneficiary and the protector. Trusts anciently are made through blood pedigree. You would go all the way back. Let's say Abdullah can trace his consanguinity back to the ancient kings, the ancient this, the ancient this. He will go up to the pedigree, the blood pedigree consanguinity, and in the consanguinity there will be a survey. See, this the crown got this from. See, they got this from the Moors. In order, when you have a trust, you have to have a survey. The survey is of minerals, marine land, fishing, agriculture, land. You have to do, like, you got assets. You got gold, silver, rubies, diamonds. That's assets. They're commodities. Animals, commodities. Lot, marine, fish, commodity. They will put that description in a survey in the trust. The survey means it's given a longitude and latitude, and it's also talking about the value of that, what it is, and how much it's worth. That's why you trusts have survey. You put the property, the corp, the real substance, the merchandise. You describe everything, the assets, the merchandise, the collateral, commodity, everything in the trust. So that's a survey in the trust. Then that trust gets sealed and signed. The trust is for the protection of the executor, the exchanger, the trustee, and the beneficiaries, all the descent of the tribe, the clans. They are the descent of the people of the land, and that they can inherit the resources and the education, the substance. When they can fish, they can hunt, they can raise animals, they can grow crops, they can mine the ground, they can snatch out of the ground valuables and use them as merchandise, goods. So that is the beneficiary. To see the benefits that the exchanger, that the trustee manager. Now, the protector is the tribe, a group of tribes, of houses that will be considered as the protector of the trust. So this is how a trust is made up. Now, you notice that the treaty between Great Britain and the United States have a survey of land, longitude and latitude of land, and it told them that they was allowed to fish. See, listen to me. They're being told. Remember fish? We talk about fish. They were told about crops, growing, where they get boundaries. So that's what the trust talks about. The substance, the real substance, commodities, and merchandise and goods that's in a political domicile dominion boundary that the people, the tribe, that first the ruling power, the crowns, or the ruling government power, consider of value. And that every house have a right to hand down for their offsprings, what they call descent, kinsmanship, and heir. This is why the crown and the privacy council have the dukes, the earls, the counts, the barons, the monarchs. They got the knights. They got all is a rank. sir,
Yeah.
saint.
Like-
Now the Catholic Church used the word bishop,
Page.
abbot, priest, deacon, clergy, right? Or they use another word,
Cardinal.
cardinal, also saint. So you see that it was going to ecclesiastical, private, public.
All right. All right. All right. So we have trust structure of the United States Constitution. Freeholders grant the colony charters from the English crown. Just review that because
Yes.
we did talk about that, but since we on this, all right, let's go back down the line. Go ahead. Freeholders grant.
Freeholders receive the letters of patent that normally comes from either the lords or it comes from the Crown and Privy Council. They are the freeholders. They receive the letter, and they are the freeholders, and their children are the successors. That's where the United States have a few disputes when land is taken that's owned by the freeholders. What the United States Supreme Court do is look back, and also the World Court do the same thing. The Hague and the international arbitrators, they look back at their own estimates. See, this is what we have to learn. In order to adjudicate now, to make a decision, final now, solid, sound, you have to go back and grab real substance. Nobody goes a fishing net in the water and pulling rocks and take them home and eat them. They grab fish. I'm just showing you, this is why when someone making a decision, no one goes look at something that just been around for 50 years. How are you going to evaluate language that's been changed 100 times, definitions and meanings? How are you going to evaluate a sovereign old nation against a modern state on a modern instrument? That's ludicrous. That's sovereignty suicide. You want to add to that?
No. Continue.
Okay, let's go to the next one. We went to this one. We practically went over the colony charters.
All right.
From the
we
English
the
Crown.
people, settlers, freeholders, received letters of patent from the English crown. We
Yes,
went over
we went
that.
through that, yes.
Colonies, industries of the English crown and
Yes, we went over that.
privacy council. Esquires, manage affairs of the freeholders and statutory bar for we the people.
Yes, now that we can go on just a little bit.
A little more.
The
right.
bar was paid to draft the Constitution and the ordinance. They are the ones under British common law, and for Spain, Portuguese. They are the ones modernly to the 16th century was drafted. But before then, they was called juris consultants that was used. The Esquires, you cannot deny, is the trustees of the Constitution because the Esquires signed the Constitution of the United States. John Adams, Esquire. Thomas Jefferson, Esquire. J. Esquire. All these officers that operate as ministers, attorney generals, governors, and Alexander Hamilton, these men are Esquires. So you cannot make a claim that I don't want to deal with an Esquire, but they're your founding fathers. I'm telling the truth. They're your founding fathers. You have found your founding fathers, the Esquire. You make all the fuss. I'm not going to address the Albion. I'm going to address the Moors that's unconscious and the Moors that seem to say they're conscious. You're going to make a claim to a protection as a protector and sovereignty based on a document that's drafted by a subject of the crown.
Wow.
You're unconscious. That's why they call you a deceased estate, because you dead conscious.
Say that again, please. Say that one more again.
You're going to base your sovereignty and your protector, your political protection of your cultural identity on a subject of the crown. And you telling me when that happens and you make a statement that the Constitution is your own to protect you, you are the dead estate. Now, you're not dead physically. You're dead consciously because you don't know who you are. If you was a native Moor, you wouldn't make. Now, I'm going to show you what I mean. Show me a Frenchman, a Englishman, a German, a Russian, a Chinese that make a claim that they're a native Moor from Morocco living in their own land. Where's that at? There ain't none. It's not even in their constitution. They derive the right as a people, an inherent right to write their political identity and their cultural, their political status and their cultural identity, who they connected with. And you telling me that you're going to turn around and look to another people whose family came in off of boats, people as immigrants and subjects, wrote an instrument granting them certain rights to vote, and you going to say that protect you? You dead consciously. You're dead. Go ahead.
All right. Yeah, you already addressed Esquires signers of the United States Constitution became the following head of states, legislators, judges, assistant to the people, the Sixth Amendment right to counsel.
Let me address that. I want them
right.
running with that.
Please,
Now,
go ahead.
when the Congress, when they amend the Constitution, the people that the common planners didn't amend it. It was the Esquires that amended, the representatives in Congress who had a vested power, inherent right. So they amended it and gave the people the same right that they had in the British common law, the right to counsel. Now, let's look at the British common law and the colony territory. Who represent the people, who represent the lords, and who represented the crown? The Esquire. He's the Sixth Amendment counsel. You have found your Esquire, your counsel, Esquire.
All right. Next page. All right. So addressing misconceptions about the English colonies. I think we've addressed some of these. One, all the English British colonies, royal charters, royal land grants, and royal letter patents have been dissolved to the British due to the British losing the Revolutionary War.
Let me answer that now.
All right.
That's not true. And this I'm explain why. Anytime the United States Supreme Court, anytime the International Court of Arbitration, anytime the World Court, The Hague, anytime international conventions bring up as a chain of proof, facts, that they read from these instruments to make prior modern decisions of sovereignty and disputes over land, territory, and domain of jurisdiction.
Yes.
Anytime it is a well-settled principle that an international arbitrator jurist, a society of jurists that's trained, and also in The Hague, when a dispute happened with two modern states, like in the United States Constitution, if diversity of citizen happened, the United States Supreme Court had what? The federal courts have jurisdiction. Well, when an international dispute happened with treaties between two nations that signed a treaty 500 years ago, well, guess what? They're not going to come in with an act that just happened 100 years ago. They have to go to the instrument. Now, earlier, Tamara read a question of one of our guest hosts, one of our audience. The Kingdom of Morocco proves that when one become conscious of they have a right to a political status based on a pre-exempt right of ancient people that possessed the land before occupiers took it over, like the Kingdom of Morocco. To say that the sovereignty of Morocco did not exist, then how did a kingdom, a state, under the doctrine of Mohammedanism, went to the embassies and claimed a pre-existent sovereignty as the Kingdom of Morocco under Mohammedanism that goes back to the 7th century, 700. Now, come on, now listen to what's going on. Then you say that, not the jurists, not the document, not the treaties. You say that Morocco's sovereignty is dead. You know why? Because you were dead, consciously. That's why.
All right. Number two, the 13 new forms of government, the 13 state governments derive their names, their existence, and their constitutions from totally different sources from that under which the old English British colonies existed.
Okay, now we have to look at this. Now let's be honest. In ancient time, there was really no constitutions. There was trusts. Yes, trusts. That's an elementary strong principle.
Okay.
The seer, a woman or a man, foresee, and was endowed with revelation, mean knowledge that was not ever spoken by the tribes or the people occupying the land. Then from that came what you call ordinance, statutes of the seer. And that governed the people as the trust, the ecclesiastical trust, because it preserved the rights to kinship, heirship, descent, as long as they stayed in line with what the seer, mean the eagle, foresee, future. He protects futures. The people are the futures. They're the salt of the earth. Then you got other governments that did not operate on that principle. They operate on their house principle of blood kinsmanship. That means the descent handed down to the house, to the clans and tribes. They came into what you call a trust, and that was their social trust. That was the first form of constitutions. See, modern constitutions now, when they got the width to strip the people of their rights, they would take someone that's wise among the people that they train and indoctrinate and castrate away from the defection of their people. That means under years of servitude, nations would take mothers, women, and they would snatch the women first. This is a war strategy. And what the nation do, they'll snatch the women and they take them in as concubines. They'll have the babies in their land. They'll send them to their colleges. The Moors done this, school them, then they'll send them back to their land. They have a right now to the land, their state, because they come from the mother. But they've been doctrinized, so they're ruled for the ruling government to keep the people in servitude to what? Language, drafting, instruments, agreements. This is the form of stripping people of their nationality, is through language, to agreements. And this is what we must understand what's going on here. So trusts are ancient. This is why the Rothschilds preserve his blood pedigree and wealth in a trust. It's called a Pew Declaration Trust.
All right. Number 3, the 13 English colonies, British colonies, became the 13 states due to the British losing the Revolution War. I addressed that already.
Yes.
All right. Thought-provoking questions for today's information. 1. Why has the definitive peace treaty between Great Britain and the United States of 1783, also known as the Treaty of Paris of 1783, been given very little attention in the general public? All right. 2. Why has the Treaty of Paris of 1783 been given the recognition and great attention in the United States Supreme Court from 1796 to the present?
Because it's not taught in public schools. That's your answer. It's not taught in grade school going up to maturity. That way now it's lost because can't be inherited, because your inherit is in education. That's how you preserve the wealth in the land, through education. Philosophy is not being taught in the public.
It's a limited, what is taught about the Treaty of Paris 1783 in the textbooks. It's very limited that, during the Revolutionary War period, in the textbooks, oh yeah, they end the war, the Treaty of Peace of Paris ended the war. That's pretty much, it doesn't go into any cases, people that don't even have that on their mind today, they don't see that as any ruling instrument at all. Absolutely.
That's right.
So that's a good answer there. All right, now, checkmate. The Crown sits as the head authority over the United States.
Yes.
Privacy Council operates as the legislative body under the monarchy. The Crown, with the consent of the Privacy Council, issues decrees and orders governing all the subjects and citizens of his or her Commonwealth's colony states within his or her political dominions.
Yes.
All right, any questions answered? Questions? All right. So, as I said at the onset of the presentation, this is a 3-part presentation. So we'll be back next month with the second Friday of February with part 2, Checkmate, the Crown's own the United States checkmate. All right, and also tune in part 2, Checkmate, the formation of the United States fiduciary guardianship of the British Crown. All right, so we have, once again, we have our upcoming course on January 27th, Thursday, from 7 p.m. to 9 p.m. Eastern Standard Time. Hooked on Grammar 301, yours truly is the instructor of the course. The class will deal with clause, class on phrases, that's participles, gerunds, and infinitives. And it's a 12-week course. And I said the class is recorded. So if you can't make it on a Thursday, because the class is recorded, you can take it anyway and then watch it the next day or anytime you have time during the course of the week. All right, tune in. Part 2, Checkmate. State formation of the United States fiduciary guardianship of the British Crown. That is the second Friday of February. That's part 2. All right. To donate, go to the Cash App, Tamara D. Ill. Tamara D. Ill. All right. Thank you, everyone. As I said before, the Academy of Providence, is the benefactor of the Moroccan Post. All right. Once again, if you want to donate, the Cash App, Tamara D. Ill. Thank you, everyone. I think this was a great ride today.
Yes.
All right.
Absolutely.
Happy Ratification Day.
That's right. That's right. Peace. So, Islam.